And now, today we will start the next chapter, civil liability, or you can say cyber tort. This chapter has been divided into four subpart. Okay, the three subpart are related to the substantive provision, and one is the procedural one. I have just shared the screen, and here this dot, is there. This dot 1, 2, and uh, below you will find third and the fourth. These fourth dot, that means these are the four subtopic, or you can say, in the four part it has been divided. See, here we will discuss cyber wrongs or civil liabilities, or you can say the wrong or the activity that has been prohibited, and for the remedy is the compensation. Okay, if someone asks to you that define the word crime, or what is your understanding of word crime or offense, can any of you would like to answer?
सर सर इसको अगर
कोशिश
हम
करिए।
सिविल रॉन्ग के मतलब सिविल रॉन्ग के हिसाब से अगर समझे तो एक क्रिमिनल रॉन्ग सर।
नहीं, क्राइम
हाँ सर,
क्राइम
विच,
आई एम।
हाँ मैं बता रहा हूँ सर। सर विच
जी।
नो विच इफेक्ट्स द ह्यूमन हैप्पीनेस टू अ वेरी लार्जर लेवल।
Oh my God, very philosophical, Akhanda. Very good, very philosophical definition. Any other? Mr. Deepak, how you will define the crime? कोई पूछ ही ले, भाई लो पढ़ रहे हो, बताओ क्राइम होता क्या है? आई थिंक इट्स नॉट वेरी डिफिकल्ट. मैंने तो बस ऐसे पूछ लिया था आप लोगों से कि सिविल रॉन्ग बता रहा हूँ तो थोड़ा सा डिफ्रेंशिएट कर पाऊँ कि सिविल और क्राइम में क्या अंतर होता है. Yes, please try.
Sir, which affect the human rights?
ह्यूमन राइट्स तो सिविल में भी अफेक्टेड होते हैं. राइट्स होगा, वॉयलेशन होगा, तभी तो एक्शन होगा. गो बेबी, यस गो.
सर बेसिक डिफरेंस तो यही है कि क्राइम ड्रॉज पनिशमेंट एंड सिविल रॉन्ग वी फाइल फॉर कंपनसेशन.
Very good, Mukesh. Very good. You all have, some extent have explained it. Akhanda, sort of, they have give the philosophical definition or the larger aspect. But how you will find out difference. The crime is an act. Act mean act or omission. Crime is an act, or you can say the wrong, that is punishable, or the crime is the violation of criminal law. Then again there is a question that which law we will call criminal or not. It's not the IPC. There in other, also like in the IT we have the offenses. So the crime is the act mean act or omission, that is punishable. Punishable means the remedy is the punishment. And the punishment is like, we have section 53 Indian Penal Code, 5 types of punishment. पहले छठवा भी होता था, ट्रांसपोर्टेशन. कौन कौन से होते हैं? डेथ, imprisonment for life, imprisonment simple or rigorous, forfeiture of property, and the fifth one is a fine. So where the remedy is punishment, that means that is offense or crime. As section 40 of Indian Penal Code define offense, but that is also not helpful for our understanding that how we will define the crime or how we will understand. And as the Mukesh very rightly said, that the civil wrong is that violation of rights. तो यहाँ भी होंगे, violation होगा तभी तो होगा. In the tort we read injuria sine deminum, deminum sine injuria. Injuria means legal injury, and damages means the damages, the the, you can say, damages to a person, nuksan. Okay, and so the wrong or the act whose remedy is compensation is civil law. Okay, so here the first dot you can see the in the share scheme is about the dispute resolution mechanism under IT Act. Generally, for the civil law, we have to go to the court, civil court, for filing the suit, and then we will get the compensation. For the criminal law, if it is a cognizable, go to the police station, file the FIR. If it is a non-cognizable, go to the court, file the complaint. क्या हो रहा है, तुम्हें जजेस बनना है, लॉयर बनना है, तुम लोग थोड़ा सा एक्टिवली गाइस. ओके, आई एक्सपेक्ट सो मच फ्रॉम दिस क्लास. इतने अच्छे अच्छे लोग यहाँ पे हैं, दीपक, मुकेश, सौरभ, all our guys are very good, huh? So so that's the thing. Now in the Information Technology Act, there is no need to go to the civil court for the certain cyber wrongs that mentioned here. For the cyber wrongs mentioned in the Information Technology, a whole system has been framed. So the forum has been created, and this forum is, the name of this forum is adjudicating officer, AO. कोर्ट में नहीं जाना है, AO के पास जाना है. So the first the portion of this chapter, we have to discuss the dispute resolution mechanism under IT Act, adjudicatory officer, and we have the adversarial system. The no both party cannot be satisfied, so aggrieved party can go into the appeal. For there is another forum, the appellate tribunal. Like company में होता है ना, company related matter will go to CLAT, company law tribunal, and then for appeal, CLAT, company law appellate tribunal. The second portion, third portion, and fourth portion are, or you can say the first portion is the procedural. The second, third, and fourth are the substantive. Substantive means that talk about rights and liabilities. So rights के बारे में बात करते हैं. So for the second dot, we will discuss the damages to computer system, computer network, denial, email bombing, etc. That means the wrong against the computer resource. Okay. In the third portion, we have to discuss data protection. And this data protection is not a normal data protection. Still, we are facing or lacking the law on the data protection. Like we in the Europe, we have GDPR, and the bill is before the parliament. The Personal Data Protection Bill 2019 पास नहीं हो रहा, पता नहीं कब होगा. But we have provision with respect to sensitive personal data protection, and that is section 43 capital A. जहां पे भी कैपिटल A B हो, इसका मतलब वो ओरिजिनल नहीं था, अमेंडमेंट से जोड़ा गया है. ये गोल्डन बात है, दिमाग में बांध लो. तो सेक्शन 43 कैपिटल A inserted in 2009 amendment. The fourth portion we will discuss that section 43 and section 43 capital A are the two substantive cyber wrong. It may be that through the information technology, some other wrongs are also possible, and that is defamation. See, defamation, property, body, mind, reputation. Reputation is well recognized right. We all have the right to reputation. And when there is the right and there is the violation, there is remedy. Okay? And so the defamation is civil as well as criminally actionable. सही तो बोल रहा हूं ना भाई साहब अखंड?
Yes, sir.
Yeah. And criminal action, section 499 Indian Penal Code, read with section 500, there is punishment. For civil action, tort, जो कुछ भी ना हो तो tort, you can claim compensation. There is a difference in the law. If you talk about India and the UK, in the UK, the defamation is not criminally actionable. And in India also, Subramaniam Swamy filed the case before the Supreme Court, Subramaniam Swamy versus Union of India. There he contended that because of this criminal action fear, people are not, cannot express as freely the freedom of speech and expression in the political sphere, because they always have this fear, journalists have this fear that criminal action liya jayega. But unfortunately, Supreme Court said that it is perfectly valid. It's not unconstitutional. So position is that in India, it is civil as well as criminally actionable now also. यूके में नहीं है, वहां तो कह रहे हैं कि इसको क्रिमिनल, क्या सिविल क्रिमिनल तो है नहीं, सिविल भी इसको एक्शनेबल मत मानो, because it have the chilling effect on the freedom of speech and expression. Suppose there is journalist, he published some news and that news was turned to be wrong, and this person filed the case against whom that news. And so it's always put the pressure on the journalist or every person that before opening your mouth, you have to be damn sure that it is true, because only truth is the exception. Okay. Now this defamation can be done by the now to information technology also. Okay. Earlier also, the defamation was, in the law of tort, I think you have read libel and slander. Okay, I'm not going in that much of detail because we will discuss when we will discuss this particular thing. And so the online defamation is the category when through the information technology, the defamation is complete. So these are the 4 areas. First, I'm picking these substantive portion. पहले राइट्स तो पढ़ ले, क्या क्या है, कौन कौन से रॉन्ग होते हैं, फिर हम प्रोसीजर पढ़ेंगे, ठीक है. सो डैमेजेस टू कंप्यूटर एंड कंप्यूटर सिस्टम, दिस सेकंड वाला जो हम जो डॉट है ये हम पढ़ेंगे, डैमेजेस टू कंप्यूटर सिस्टम 43 वाला. ओके, प्लीज open your Bayret and find this section 43 under the chapter 9. Yes. Mila?
Yes, sir.
Yes, please read.
So section 43, na?
Section 43.
Yes, sir. Penalty and compensation for damage to computer system, etc. If any person.
So now the first thing here is that sir, आप तो compensation कह रहे थे, इन्होंने तो penalty भी लिख दी, penalty punishment type से. And what is the justification for that? Compensation तो ठीक था, adjudication मतलब आगे procedure भी उन्होंने बताया हुआ है. But why this word penalty? Can any of you would like to explain it?
Sir, if the act is illegal, sir, then the penalty is put on.
Sir, maybe it tried to cover both civil and criminal wrongs.
See, as such, it's not appropriate or proper here. That's my personal opinion. Okay. Because the word compensation is had to, only the justification you can see that the same things that has been defined here, if done with dishonestly or the fraudulently, that means mens rea also, if we coupled, then it will fall under section 66. Section 66 says that if any person with dishonestly and fraudulently do any act prohibited by section 43, so फिर उसका punishment, that means it making it as offense. Because for the criminal act, the criminal law, we read this maxim, actus non facitrium nisi mincitria, an act is not crime unless and until it is coupled with the guilty mind. Mens rea is important. Throughout section 43, you will not find that there is any requirement of mens rea. But in the section 66, because that is under the offense chapter, so there must be a mens rea. पढ़ाया होगा ना आपके क्रिमिनल लॉ टीचर ने. और मेंस रिया का या तो ऐसा वर्ड हो जैसे कि इंटेंशन हो, नॉलेज हो, रीजन टू बिलीव हो, डिसऑनेस्टली हो, फ्रॉडेंटली हो, मतलब कुछ भी ऐसा वर्ड जो मेंशन किया, because it's always the duty of the prosecution to prove all the ingredients of the criminal provision. And so with that perspective might be, this word penalty, they have written it, this is only justification, otherwise it's not justified here. Okay, yes, please read. If any person.
If any person without permission of the owner or any other person who is in charge of a computer system or computer network
Yeah,
assesses.
stop, itna jaldi nahi. So here on the three things we will discuss. First is any person, गोला भी लगा सकते हो आप डायरेक्ट में. Second is without permission, and the third one is this phrase owner or in charge of the computer, in charge, owner or the person who is in charge. Any person means it may be natural person as well as juristic or artificial person. Okay, person means any entity to which rights can be attached and liability can be imposed. Legal transaction can done only between two persons, and the concept of personality or person is very important. But I'm not going in that detail, maybe some other day we will discuss, because if we start discussion on that it will take one class. And so person means natural person like we and you. Okay, it may be natural person, may be citizen, non-citizen, immaterial. Okay, India ka ho, Pakistan ka ho, kahin ka bhi, so that may be human being. Second is juristic person like the company, state, or any person that have in the law, in the eyes of law, it is done. तो wrong तो वो भी कर सकता है. Okay, any means it's covering, the sweep is so wide. Raja, rank, dost, दुश्मन, wife, husband, girlfriend, कोई, सब पे sweep is wide. There is no exception recognized. And the first case that is mentioned in your case material, और कलयुग आ गया. वाइफ ने हस्बैंड की ईमेल चेक करके डाउनलोड कर ली और हस्बैंड ने उस पर केस कर दिया. Because any person means any person, wife भी. So this any person, this word any means it's covering every, without in how much intimate relation you are, you will not be escaped from the sweep of this section. This word any is such a powerful word. Okay, and so your father, your boyfriend, proudly you can say that section 43 is with me. So that's the any. In detail we will discuss that case also, we will discuss. Let us come to the without permission. Yes, Mr. Deepak, bolo.
Yeah, sir, I wanted to say, when we say without permission, so at times the permission was taken without the consent as well. Like when we go to downloading any website and all,
अरे
then we provide.
परमिशन पे मुझे बोलने तो दो.
So you mentioned without permission.
बस अभी कहा है, अभी इस पे मैं भी अपना
Okay, sir.
without permission. Without permission means, and this without permission has to be read in relation to the two words that is used later on, owner or the person who is in charge of the computer system, computer network. Okay, without permission. This permission may be express means it is in the words written or spoken. Okay, but you are able to, you have to be able to prove if there is some civil suit against you, civil action, then you have to that it was with the permission. But the liability is to you that prove to rebut if he said that without permission, because the liability or the burden of proof is different in civil and criminal case. In the criminal case it is beyond reasonable doubt, but in the civil case preponderance of the probability. So suppose जिसका डैमेज हुआ, पिटिशनर हैज प्रीपोंडरेंस ऑफ द प्रोबेबिलिटी प्रूव कर दिया, then you have to rebut it. So this permission may be expressed that, like, it was the oral, and you can prove by adducing some through the testimony by witnesses, or it may be written. Written may be on the documentary form or in the any electronic record, or it may be implied. Maybe implied you are in the authority and that's why you did that thing. So it is implied. Okay, so that, yes. Now you ask the question. Deepak, now you ask the question.
So I always wanted to ask you, like, the permission always not like that need to with consent as well. Uh, like
Permission, consent, in what sense?
like
Would you elaborate?
yeah, like I'm a owner of this computer,
Mhm.
and if I'm going to download any software, so that needs a permission to allow the access of location and all other things. At times we don't go through the whole thing whatever mentioned, and we just give the permission to that. But I don't
So,
want my location.
suppose someone is having that particular open, uh, you know, access. That does not mean he has the permission. Okay, that does not means he has the permission. Your car is parked outside, कहीं खेत में भी खड़ी हुई है, that does not mean कि कोई आए और उसे चुरा ले जाए. Okay, so permission means, and you have to, whenever the other person prove that it is without permission, as a defendant you have to rebut it. So the question will remain with you that how you will rebut that it was the permission. Okay, now the next word or the phrase is owner. Owner of the computer, like you have your computer, desktop, laptop, your mobile, or person who is in charge of, like a person is in the police department and in that department computer are allotted. So state is the owner, that the person who actually using that computer. और सपोज यू आर वर्किंग इन ए कंपनी, जब कंपनी में वर्क करते हो तो कई बार कंप्यूटर वो दे देते हैं, तो कंप्यूटर का मालिक कौन है? कंपनी, बट यू आर इन चार्ज. इन आवर लॉ फैकल्टी LC1 की लाइब्रेरी में देर आर कंप्यूटर्स, और इन आवर ऑफिस LC1 के ऑफिस में देर आर कंप्यूटर्स. द ओनर इज द दिल्ली यूनिवर्सिटी, बट पर्सन हु आर इन चार्ज उसमें लाइब्रेरियन है और उसमें वहां पे जो ऑफिस बेयरर है. सो दैट थिंग. Okay, now read clause A.
Accesses or secures access to such computer, computer system or computer network or computer resource.
एसएसएस नहीं, इसको एक्सेस बोलते हैं. जब दो सी आते हैं ना, डबल सी, तो एक सी का कै बन जाता है, दूसरी सी का से बन जाता है, एक्सेस. ओके, एक्सेस इज और सिक्योर एक्सेस to such computer. Such, this word such means who is without that permission. Okay, computer system, computer network, or computer word. So this such word is again referring to that computer to which permission has not been taken. Okay, here the word computer, computer system, computer network, these we have already defined. We have invested many classes, so we clearly understand. The only thing is that accesses or secure accesses, and why two words? The two words here, accesses or secure access, are with a purpose that to cover even the attempt of making the access, the process of accessing, and when the process is completed, the person got the access. So that is the relevance of these two words. Then the question is, what is meaning of the word access? The word access has been defined by the section 2A of the Information Technology Act. And section 2A says that access with its grammatical variation and cognate expression. Grammatical variation means present में, past में, future में, like access is secured access, कोई present और उसमें past में, means gaining entry into. The first thing is gaining entry into, instructing or communicating with logical arithmetic memory function resource of a computer, computer system, or computer network. So these three words will come with the logical, arithmetic, and memory function. Gaining entry into logical function, gaining entry into arithmetic function, gaining entry into memory function, instructing to logical function, instructing to arithmetic function, and similarly with the communication. Gaining entry does not mean that physical entry. It may be virtual, that you are not physically making the access, you are somewhere else, but through the technology, okay, you are able to get the access, that we say the hacking in the common parlance. So that you are doing, that you are making access to the computer, and that is without, you know, the permission. And so, sorry, any act by which we are instructing to our computer, any act by which we are communicating, by any key you put without the permission, any direction you give to the computer, whatever we type or we write or we find out, that in the computer term we say that we are instructing computer to do that. Okay, when we click on the phone button, we are instructing that open the phone book. When we click on that, we are instructing to the our mobile phone that call to this person. Okay, so this is the instructions or events the communicating. अब यहाँ पे ये हम डिस्कस कर लिया. Now you read the last line of the section 43. Last में जो है shall be liable. Yes, Akhand?
He shall be liable to pay damages by way of compensation to the person so affected.
Yes. Now there is this word to pay damages by way of compensation. And so the remedy is compensation. And this again reaffirm that section 43 is actually talking about civil liability, cyber wrong, civil wrongs, because the remedy is compensation, not the penalty. The damages, to pay the damages, what's the losses you have suffered, for that the damages. And damages जो देगा कोर्ट आपको कंपनसेट करने के लिए, जो अमाउंट देगा, that damages, in the journal we define or we categorize damages into two categories: liquidated and unliquidated. Can any of you differentiate or would like to define that what is liquidated damages and what is unliquidated damages? थोड़ा
Sir,
वो
liquidated damages are given in breach of contract, while unliquidated in as a compensation in tort. And sir, liquidated damages जो है वो predetermined होते हैं और
very good.
unliquidated
Wow.
court decide करता है.
Well, very well he has defined. Very well he has defined that is predetermined. The damage कितना होगा वो पहले ही आपको पता है. Predetermined and generally given in law of contract, and here is law of tort. So it is in the compensation. तो ये वही वाला portion होगा civil वाला. It is not the, because here जो relation breach हो रहा है without permission वाला, वो कोई contract वाला relation नहीं है. And so here it is unliquidated damages. वो predetermined नहीं है, that will be determined. Section 47 put some criteria and accordingly will be determined. That is not predetermined. Okay, so for each clauses like A, B, C, जो ये section 43 में है, you have to read first two line, then that clause, then last one line. That would be the complete, and then accordingly you have to discuss. Now I'm reading. If any person without permission of the owner or other person who is in charge of computer or computer system or computer network accesses or store accesses to such computer, computer system, computer network or computer resource shall be liable to pay by way of compensation to the person so affected. Okay. Now read clause B. And this first wrong, section 43 small a, इस रोंग का आप नाम रख सकते हो, लाइक टॉर्ट में भी तो रोंग होते हैं, नेग्लिजेंस, डिफेमेशन, अलग अलग. यू कैन नेम इट एज अनऑथराइज एक्सेस. ओके, लिख भी सकते हो आप अपना डायरेक्ट में भी लिख लो इस पे अनऑथराइज एक्सेस. यस, प्लीज रीड क्लोज बी. बी पढ़िए.
Downloads, copies, or extracts any data, computer database, or information from such computer, computer system, or computer network, including information or data held or stored in any removable storage medium.
Yes, this wrong is known as data theft. Okay, here it talking about download, copy, or extract. Three words are given. Download means that you either physically or present at that place, or through you are remotely, virtually, you are able to download whatever the data that particular person has in his computer. Okay. The second is copy. You have not downloaded it, but you make the copy of that, and that copy you have taken. Copies. Okay, so the word copies means you are not making the copy but taking the copy of that to your. And then the third is the extract. Extract means not the whole data but some portion of the data you have taken, and then it's saying that to the data or the computer database or the information. That words we have already defined. And it also include the information or data that is stored in the removable storage medium, your laptop, floppy, hard disk, etc. Okay, now again you have to read with two lines and these clause b and then that. With that, I would like to discuss the first case also, Vinod Kosik versus Madhvika Joshi. And this case is important for 2-3 aspects. One, to explain that the any person means any person, it may be wife. And the second is that you will find the opportunity to these clause A and the clause B, that whether what are the requirements, etc. Before that, I want to take 2-3 example also, because the problem of the IT Act in the offenses also you will find कि कोई illustrations नहीं दिए गए हैं, like we find in the IPC. illustration से ना clear हो जाता है चीजें. Explanation and illustration are not law. That is the rule of interpretation. They does not increase or decrease the scope of the law, but they are only explaining. The law is that is within the lines. Even the marginal note is not the law. Marginal note कुछ कहता रहे, अंदर कुछ होगा, वही law होता है. Okay. Suppose you have a mobile phone. हमारे अखंड के पास एक मोबाइल फोन है, एंड बहुत ही प्यारा से इन्होंने उसने पैटर्न लगाया हुआ है, एंड some person without his permission want to open that phone, want to do something, so he just draw 2-3 times that pattern, but he could not decipher, all were wrong, and so mobile phone could not open. Or you can say mobile phone was password protected to open it, but some person without the permission of this person has put the password, but all were wrong, and so it could not open. और एक बार उसने किया, wrong था. So whether it is access or you can say it is covered under section 43 small a or not.
Yes, sir, it is covered, as he tried to secure access.
Any other?
Yes, sir. In 43A, secure access. That means, sir.
And the word secure, importantly, the word secure is saying gaining entry or instructing. When you are putting the password, that means you are instructing to that particular computer device that open it, this is the password. That different thing, it was wrong. But you are instructing to its function, logical, arithmetic function. Okay, so that means you are instructing to the device, you are communicating to the device and so that is also covered. And so that's the important, that maybe you are not able to say that he secured the access, but he is accessing, he is communicating to device. Okay, so that is the this thing, this example I have given. Similar, the you have the laptop, some person came into your house, he is your guest, and then he just open without your permission, ना पूछा ना और कुछ किया, आपके मोबाइल में उसने इंटर किया, and then he downloaded some copy, etc. What offense, what sorry blender, what wrong he has committed? Two wrong he has committed. First is section 43 small a, when he opened it and then gained access. Then section 43 small a, and then he downloaded. Then section 43b. Okay, maybe there is one person B, and he, is somewhere else. He got, some by any technology, because he's very tech savvy, and so he able to access your email account, and he got access to your computer, and then remotely he's operating. Same, he is accessing, because access does not means that physically you have to present or not. It's only by any means you are gaining, by any means you are communicating, by any means you are instructing to the computer, that is access. Okay, similarly download copies, etc. It's not saying that you have to download only from that computer, maybe from somewhere else you are downloading. So that's it. Okay, now come to this particular case. First case, मैं इस पे भी निकाल देता हूँ, Vinod Kosik versus Madhvika Joshi. We will be slightly fast so that we can complete this, because only 4-5 minutes we have left. What happened, that there was a person, Mr. Neeraj Kaushik, and he married to one girl, Madhvika Joshi. Neeraj Kaushik father is Vinod Kaushik, who is the petitioner here. And so the relationship between Neeraj Kaushik and Madhvika Joshi got strange. अच्छा relation उनका नहीं चल रहा था, दहेज वहेज की डिमांड करते थे. It was allegation from Madhvika Joshi, and Madhvika Joshi want to file a complaint under section 498A IPC, Indian Penal Code. So she got access of the husband के, husband तो अपना ही है, इससे ले लेते हैं इसकी मेल पे, and अपने ससुर की मेल से she got she made the access, and then she downloaded some conversation, email conversation, and she filed with the police authorities in support of his case. Okay, simple case. Now these two person, Vinod Kaushik, the father-in-law, and Neeraj Kaushik, उसका husband, they want to take the criminal action. क्वेश्चन भी ऐसे पूछते हैं, and they want your advice. Okay, so under which section you will advise them to take the action? Civil action they want to take. कौन कौन
So
सा?
43A, 43 small a.
43 small a, and 43B नहीं आएगा, जो डाउनलोड भी कर लिया उसने ईमेल कन्वर्सेशन को?
Yes sir.
So section 43A and section 43B both. ये बात नहीं है कि वो वाइफ है, कोई रहम नहीं.
No sir.
इम्प्लाइड अथॉरिटी नहीं मान सकते.
Sir, it is written na, any person.
Yes.
So
And so what happened in this case also, they filed the they want to take the civil action, and they filed the before the adjudicating officer. Adjudicating officer भी बड़ा funny आदमी. Adjudicating officer, he said that yes, section 43A B attracted, there is the wrong committed by this lady. Okay, but he have not allowed, or he have not awarded any compensation. Rather, he has fined this lady of 100 rupees. फाइन डाल दिया बस. अब वो पता नहीं मिसलीड हुआ यहाँ वर्ड पेनल्टी से लेके या कैसे, and agreed by this action of the adjudicating officer, this order, these petitioner, uh, Vinod Kosik, they approached, they want to file the appeal, but उस समय appellate tribunal was not, chairman was not there, and so it was not in position to function. So they filed the writ petition under Article 226. And before the High Court, the question they have filed that, see, the adjudicating officer have not awarded any compensation. We want 50 lakh compensation. And how that compensation? First, on the ground that this lady, by downloading, getting access and downloading email conversation, has filed false case 498 केस के कारण मेरा बेटा जो है वो यूएस से नहीं जा पाया. The third is that there was some consignment that they were not able to take. Then there is all these things you will find on the second page. Then this overseas business assignment, they has not been taken. Then there is blocking of the client, etc. Then there is the blocking various business opportunities. Along with that, we have to file this case also for compensation. 1,03,000 फीस भरी है, 50,000 का we have hired lawyer, 5,000 for documentation, and we came here and we lodging, होटल लिया है, सारा लगा के बोले 50 लाख का कंपनसेशन. हाई कोर्ट से मांगो तो ज्यादा मांगो, कम क्यों मांगना, इतना बड़ा कोर्ट है, बोले मांगे. And the second thing is that it means the compensation should be awarded. The adjudicating officer was wrong in that for not awarding compensation. The second thing is that adjudicating officer has imposed the fine, but the adjudicating officer is the civil authority. He cannot impose the fine. Two things. Now the High Court, said that yes, Section 43A(b), violation of Section 43 is there. Wrong has been committed by this lady. But for the compensation, it's like, in the civil cases, we have to say that damages by way of compensation. There must be some damage, नुकसान होना चाहिए कुछ. And that damages you have to show, this from there, on the first page, first, second, third, fourth पैरा यहां से देखो पढ़ो. The claim for compensation, is it visible?
Yes, sir.
Second last में, the claim for compensation would arise not merely on account of breach of Section 43. The claim would have to be established like a civil court by making requisite averment with regard to damage suffered, and thereafter by leading evidence in support thereof to show that one or the other prohibited activities enumerated in Section 43 of the IT have resulted in sufferance of the damages to the by the person concerned, and you have failed to that. उन्होंने कहा नहीं, हमने तो दिखाई है ये सारी. So there is the rule that the damages should be direct damage. In the contract में भी पढ़ा होगा, Hadley versus Baxendale, बहुत पुराना केस है, Section 75 is on that. Hadley versus Baxendale, applicable in the law of contract for the compensation. But it teaches that in the tort also the damages must be direct. नुकसान आपका डायरेक्ट होना चाहिए. You have given your shirt or your pant coat to a person or get it press. आपकी सोसाइटी के बाहर प्रेस वाला बैठता, उसको प्रेस कर दिया, वो बंदा कोट को जला ही दिया, उसमें पूरी प्रेस बाहर निकाल दी. अब आपने उसको कंपनसेशन हुआ तो आपने एक कंपनसेशन तो ये कह दिया कोट जला दिया 5,000 का. दूसरा जी मैं कोट पहन के नहीं गया, मेरी नौकरी नहीं लगी, शादी नहीं हुई, बच्चे नहीं हुए, और ऐसे करके तुमने कई लाखों का कंपनसेशन कर दिया. तो would this person would get that compensation? The compensation would be given when they are direct. Remote compensation cannot be given. Okay. So here the court said that what the case has been filed, that case is not because she downloaded. The case is on the wrong you have committed, and that is punishable under section 498A. The second thing on the third para here, यहाँ पे ये जो second para में जो है बड़ा सा ये वाला para here, that C has not used the said information for any other purposes such as malign the petitioner or cause any loss to them, and the information retrieved by her has been given only to the police authorities or the court. On the basis, the adjudicating officer has held that the petitioner is not entitled to claim any damages. Okay, so similarly, thing also accepted by the court, that direct damage is not there, and so you cannot, because direct damages would be that if she made it publish and वो कुछ इनकी रेपुटेशन को नुकसान होता है या वो और चीजें होती, 498 केस है वो तो उसी पे है, and in consequence of that, your son was arrested, in consequence of that, you were busy in that whole process, so you could not get the delivery, your son could not go to the abroad, और उसी का एक्शन लेने के लिए आप ये झूठे जो है यहाँ पे you came to the adjudicating officer and all these things, and so no compensation. Okay. On the second ground, that civil adjudicating officer was wrong because it is civil forum and cannot impose the penalty. High court said penalty तो माधविका पे अप्लाई हुई है, आपको इतना टेंशन क्यों? So the penalty was on the defendant Madhvika Joshi, and let her take the action. Why you are worried? And so both question decide against, and so in the last or you can say on the last of the case, these para number 39 etc you can read. These are the gist of this particular case, para number 39, that since the complaint is legally tenable and the complainant Neeraj Kaushik are entitled to relief as paid by having the cost on the respondent along with respondent economically, the foresheet claim has been rejected by adjudicating officer, and in my view, rightly so. In my view, rightly so means the High Court is also saying the right of the respondent to pursue the legal remedies available to her, including under section 498 IPC, cannot be questioned. The invocation of right available to the person to ventil his or his grievance and to take action against the perceived illegalities and criminality does not give a cause of action to claim the damages to those against whom the action may be initiated because of such complainant action, unless it is eventually found that such complaint was malicious. तब तो आप कह सकते हैं. And then this last para, so for the submission with regard to levy of fine 100 rupees under section 66C concern, I find no merit in this either. Submission of the petitioner in this respect is said fine cannot be imposed by the adjudicatory officer who function like a civil court, where fine is imposed as a criminal court dealing with the offense made under this act. The fine has been imposed by section 66C against the respondent 1 in case it is aggrieved to state taken on fine. So these para section, this para 39 you have to read. Please read this case. With this case, we come at the conclusion, two important things, that section 43 applicable even to the wife also, wife, girlfriend, boyfriend, father, mother, how intimate relation you have, and some other things also we have discussed. Yes. Now, if you have any question, any query with respect to this particular discussion, please ask.